seek a lordship indulgence.
Yes.
In mentioning item number 3 and 4 of hearing list,
Huh.
I have taken the consent of the counsel for the respondent, my lord. If this may be taken up after some time, maybe after 2 weeks, my lord.
After 2 weeks.
Yes, my lord.
Okay. Mr. Victor L. Relatives, letter counsel for the petitioner, prays that the matter may be listed after 2 weeks and submits that the consent of the opposite parties has also been obtained. So accordingly, list the matters after 2 weeks for hearing. Yes.
Yes, my lord. And item number 16 of hearing list, item number 16.
Item 16. Yes.
Here I am the amicus for the appellant. If this may be taken up after a week.
After a week.
Yes, ma'am. I have taken
Item
consent.
16, yes, with the consent of the learned PP, learned amicus, Mr. Victor L. Realty prays for listing the matter after 1 week. Stop. Accordingly, list after a week for hearing.
Deeply obliged.
Yes.
Seek your lordship's indulgence in mentioning item number 11 and 12 of part 2. With the
11 and 12.
Yes, your lordship, wherein I am the appellant and I have taken the consent of the opposite parties. If this matter may be taken after a week, your lordship.
After a week.
Yes, lordship.
Learned counsel, Mrs. Judge, for the appearing for the appellant, has prayed for listing the matter after a week, and it is submitted that the consent of the opposite party has also been obtained, who has no objections. So list after 1 week.
Moreover, lordship, item number 13, wherein I am the respondent for respondent 1 to 4. I seek the same.
13, 1, 3.
Yes, lordship.
Okay. You are for
Respondent 1 to 4.
1 to 4. Here, when do you want?
Lordship, if this matter may be taken after a week as well.
This one was after a week.
Yes, lordship.
List the matter for hearing after a week on the prayer of the learned counsel, Mr. Such and Such, for respondent number 1 to 4. What about the appellant? No objection?
No.
Learned counsel for the appellant is present and has no objections. Yes.
Obliged, my lord.
Formation, item 1.
May I please your lordship?
Yes.
Lordship, I am
Yes.
appearing on behalf of Sanjay Kumar Mehti for respond number 5. Lordship, my senior is in before the court number 1, Lordship. Lordship, kindly may fix the matter on 28th of October. He will be physically present before your Lordship.
28.
Yes, Lordship. And in this matter, Lordship, as per order dated 17/6/2005, we have filed a review petition before the principal bench, Lordship. Is pending.
You are for the petitioner?
No, Lordship. I am for the respondent, respondent number 5.
Respondent 5. What about your affidavits? Affidavits filed?
Yes, my lord.
Okay. And notices on all the respondents
All
complete?
respondents, yes, have received or completed, my lord.
Okay. So she's praying for listing on 28 then. Is that okay?
And I have no objection. However, my lord, regarding the review petition that my learned friend has just announced, we have not received any notice from their part.
Have you served copies?
Yes, Lordship, we have filed it on 22/8/2025.
22/8.
2/8, 2nd of
2/8.
2/8.
Learned counsel, Ms. Such and Such, appearing for respondent number 5, has submitted that a review has been filed against the judgment and order where is the WPC against the
At page number 12 of my petition, my lord.
judgment and order dated 19/3 2020 in WPC number 148 of 2019 on 2/8/2025. Stop. And the same is pending. Stop. Learned counsel submits that prays that the matter may be listed. This matter may be listed on 28/10/2025. Stop. Learned counsel for the petitioner has no objections. List on 28/10/2025. Any order passed in the review?
No, my lord. It is pending, my lord.
I'll inform on 28,
List
madam.
on 28, yes.
Obliged.
Item 2.
Your Lordship,
Yes.
I'm here for the responding, Your Lordship. But Your Lordship, however, if Your Lordship may kindly allow me to make an adjournment of the matter for next week. Since
Are you filing any objection?
We are, but Your Lordship, the leading counsel, he's not able to show up today. So,
Learned Counsel, Miss such and such, appearing for the sole respondent.
yes, Your Lordship.
Appearing for the sole respondent. Stop. It is submitted that the leading counsel for the sole respondent has some difficulties today, and therefore it is prayed that the matter may be listed
On
after
on the 30th of October.
on 30th October 2025. Stop. Prayer is allowed. Learned counsel for the petitioner is present and has no objection. Stop. List on 30/10/2025. Stop. The sole respondent may file the objections may file objection if so advised. Okay. Within that time, if you wish to file, you can file.
Much obliged, Your Lordship.
Item 3.
Yes.
My Lord,
Pleadings complete.
no, my Lord, respondent number 6 has not yet filed
Respondent number 6.
My Lord, I'm for the newly pleaded respondent number 6.
Hmm.
I am seeking another 3 weeks' time for filing affidavit.
Okay. Learned counsel for the petitioner, Miss Emily L. Camp is present. Stop. Learned government advocate, Ms. Mary such and such present. Learned CGC, Miss such and such prays for how much time?
3 weeks.
3 weeks time to file affidavit on behalf of the newly impleted respondent number 6. Stop. Accordingly, prayers allowed. List after 3 weeks. Yes.
Item 4.
In this case, my lord, I need to file my reply against the affidavit of the state, and I'm seeking further 3 weeks' time, my lord. Due to the fact that I have applied for RTI application, and I have received one response. In the other, I'm still waiting for the response.
Still awaited.
Yes, my lord. So
How much
if I'm
time?
granted
How much
another
time?
3 weeks' time, my lord.
2 weeks.
3 weeks'
3
time, my
weeks. Learned counsel for the petitioner, Mr. No. Yes, learned counsel for the petitioner, Mr. Victor Ragde, submits that he is yet to file the reply affidavit to the counter filed by the respondents.
State.
And has state respondents, counter filed by the state respondents. Stop. He has accordingly prayed for 3 weeks' time to file the same, as he is awaiting certain documents through an RTI application. Stop. Prayer is allowed. List the matter after 3 weeks. Learned government advocate such and such, and learned counsel Miss Emily such and such for respondent number
My Lord,
1.
1 to 3.
1 to 3 is present.
My lord, the interim order may be continued forward.
Excuse me? Interim order?
Interim order, yes, ma'am.
Okay. Interim order passed earlier shall continue till the next date.
Item 5.
My Lord, I file my power for respondent number 2.
Respondent number
2.
2. Okay.
I may be given 3 weeks' time for filing my so-called reply.
Okay. Otherwise, AD cards still awaited for 1, 3, 5, 6, and 7. The learned counsel for the petitioner, MS such and such, is present. You give your name later. Stop. Respondent number 2 is represented by Miss such and such. Stop. AD cards on respondent 1, 3, 5, 6, and 7 is still awaited. As per the office note dated 21/10/2025. So accordingly, the learned counsel for respondent number 2 seeks 3 weeks time to file an affidavit on behalf of the respondent 2. So accordingly, list the matter after 3 weeks, awaiting notice of service awaiting service of notice on respondent 1, 3, 5, 6, and 7. Stop. The learned counsel for respondent number 2 may also file the affidavit.
Item 6.
My lord, with item number 6 also, I file my power for respondent number 2.
Here also,
Yes, my lord.
okay. Same order, but here you say that return of AD cards from the rest of the respondents still awaited. Stop. So list after 3 weeks, awaiting service of notice on the rest of the respondents. Stop. The respondent number 2 shall also file the affidavit if so advised. Stop. Same counsel for the petitioner also. Okay.
Item 7.
Learned counsel for the petitioner is not present when the matter is called. Stop. Learned PP, Miss additional PP, Miss Vani Siami is present. Stop. List after 2 weeks. List after 2 weeks.
Item 8.
What is this IA for?
Your Lordship, this is an application for condonation of delay. Your Lordship, in my case, there has been a total number of 1,883 days delay in filing the connected appeal.
1,883 days.
83 days. Yes. Your Lordship, some of them are within the COVID-19 pandemic. So, Your Lordship, before I proceed with my submission, may I go to
All
my
parties are present. Yeah. Okay. Yes.
Yes. Your Lordship, the appeal was filed against the order dated 26/2/2023. That order was passed ex parte against the applicants herein. So since the order was passed ex parte, the said order was not known to the applicants immediately. So after on gaining knowledge of the same, they approached a counsel who advised him to file a review petition. So the review petition was filed on 9/3/2021, but the trial court dismissed the petition on the ground that there is no error apparent on the face of record. So the
After the ex parte order, you preferred a review petition.
review petition, Your Lordship, and that review petition was disposed of
Same
on
was disposed.
8/4/2022. And thereafter, Your Lordship, an RFA was filed. RFA was filed, but that again was dismissed on the ground that there is no jurisdiction.
Pecuniary jurisdiction.
Yes. And again, an application under Order 9 Rule 13 was filed. That one also dismissed.
Then after that, again IA was filed.
Yes, Your Lordship.
That was also dismissed on 13/7/2023.
Yes, Your Lordship. So, Lordship, since the applicants were not having any knowledge of court proceedings, they blindly depend on their counsel. So, on the other hand, since their counsel, instead of advising them to file an appeal, he pursued the execution case which was filed by the respondent herein. So in this regard, in the previous court, I was given permission to file additional affidavit to substantiate my claim that I have pursued the execution case filed by the respondent. In this regard, I have filed an additional affidavit.
So after excluding all the time during the COVID pandemic and excluding the time of the litigation before the trial court,
Yes.
this 1,883 days is there, or this is inclusive of all?
Inclusive, yes, inclusive of all.
Inclusive?
Yes.
So if you minus all those, then how many days will it be? Because you should have put both, inclusive of the time spent before the trial courts and then the time of COVID.
Yes.
If you exclude that, that also will be a different figure.
Yes, Your Lordship,
So,
in this regard.
because this 1,883 days, it appears it's a total.
Yes, it's a total. So regarding that COVID-19 pandemic, I have to submit one power.
This one, the order of the Supreme Court, it's already here.
Yes. Your Lordship, as
That's
per that,
Somoto case.
yes, Somoto case. As per that judgment, the relevant portion is at page number 4, Lordship. Paragraph 5, sub number 3, Roman number 3. May I read, Your Lordship?
Yes.
In cases where the limitation would have expired during the period between 15/3/2023 till 28/2/2022, notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 1/3/2022. In the event the actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, that longer period shall apply. That means during that pandemic period, the limitation period has to be counted from 30/5/2022, because all persons shall have limitation period of 90 days counting from 1/3/2022. So that limitation period starts only from 30/5/2022. So if we minus that period, the number of delays would reduce to 1,149 days. Your Lordship, during the COVID-19 pandemic, the review petition has already been disposed, and thereafter an RFA was filed, and thereafter another CMA was filed under Order 9 Rule 13. That application under Order 9 Rule 13 was dismissed on 13/7/2022.
No, that's why I'm saying
Yes.
the
That
One part is, you have two parts to your
Yes, two
application. One part
Yes.
is that COVID period.
COVID-19.
Then one part is the time spent during litigation,
Yes.
before the trial
During
court.
that litigation, there is another 409 days.
So after that, now how many days remain? You minus that 409 also.
Yes. Your Lordship, there's still left 775 days.
775 days. This you have to explain.
Yes. In this regard, our Lordship,
So 775 days, you're attributing everything to the council,
yes.
that it was the council's fault,
So,
that they took
out of
time.
that, out of that 775 days, that
See, your condonation application is not properly drafted, because you have to give exact, from this date to this date it was this, from this date to this date it was this. You know, you have to state like that. But
Yes.
it's just a general thing. You have not stated about the dates. Nothing is there.
this, but Your Lordship, since the application was dismissed, the applicants are supposed to file an appeal before this High Court, but
Yes. But instead of that, you
yes,
are filing
Your Lordship.
RFA before the district court.
they were blindly depend upon their counsel, thinking that their counsel would follow correct legal strategy for their case.
So what does your additional affidavit say?
In my additional affidavit, my Lordship, I have annexed the order sheet, daily order passed by the trial court, wherein an execution application was filed. So the previous counsel, instead of advising my client to file an appeal, he contested the execution case. So if the previous counsel advised the applicants to file an appeal, they would have filed the appeal. But since they were an innocent person having no knowledge regarding the proceedings of the court, they do not know the necessity of filing an appeal, so they blindly depend on their counsel. So, on the other hand, their previous counsel,
And
Has pursued the-
you are appearing before the executing court also? You are appearing?
no, Your Lordship. I
Oh,
represent-
execution application is also disposed of.
It is still going on, Your Lordship. Your Lordship, the execution case was filed immediately after passing of the ex parte order.
Order dated 23/1/2023. In the execution case, here it says execution application is therefore disposed of.
23.
Page 28 of your
Yes.
additional affidavit.
But case record has been called.
Judgment debtors shall vacate the property covered under such and such. The JD shall demolish, the judgment debtors shall demolish all the properties, all or any of the properties which is constructed by them. Such and such.
But thereafter, Your Lordship, the case record was called on for further proceeding on 21/2/2023, which is at page 30, and proceedings were started again. Though
Okay, yes, respondents, are you objecting?
No sufficient cause whatsoever has been shown. The judges simply blamed their previous counsel without showing any reasons or any documents to prove that the previous counsel was incompetent. And just because they changed their counsels, they cannot skip the limitation dates. They've just stated a huge number of dates for filing their cases. And in any case, since the last order in the CMA application was passed in 12/7/2023, more than 750 days have passed anyway. And they were still pursuing the execution case. And now they're simply blaming their previous counsel without any documents to show any cause of delay.
That's why I'm saying, even after deducting the COVID and after deducting the period spent litigation, 700 we have calculated as, yes, that there is no explanation, just blanket statement that so many days was spent for preparing the so and so.
In fact,
207 days for preparing the said application. How many, so many days?
They are also very aware of the court proceedings, my lord. In fact, the executive magistrate and the police have gone to the site of the property on 3 different occasions, and they were unable to evict them because they just refused to leave. So, on the last date, my lord, the house was sealed off, and they were made to live outside. It was only then that they started to pursue the matter and approach a fresh counsel. And that reason cannot be considered to be sufficient cause for any delay. The appellants were simply under the impression that if they kept ignoring the orders of the court, everything will go away and they just keep occupying the property illegally.
Your Lordship.
But one thing we have to remember is that it was ex parte also. It was an ex parte order. And
but in any case, after the ex parte order, appeals have been filed. And even considering all those appeals, more than 750 days have elapsed since those appeals were disposed of.
Your Lordship, if may,
And before the eviction suit, what was there a title suit before this?
No, my lord, they have nothing. They
And-
just simply occupy
and
the
Your
lands
Lordship,
and we
if
find
I may
them.
be allowed to submit, in the eviction suit, no document was examined by the court, no exhibit was there. In spite of this, the trial court has passed the ex parte order in favor of the plaintiffs. So, in fact, the appellants herein were occupying the suit land by constructing their respective houses. So, Your Lordship, if I may be allowed to submit some citation, because the ignorant person shall not be held liable due to the mistake committed by their counsel. In fact, they were not informed about the necessity of filing an appeal at the relevant time. Had they were informed about the necessity of filing an appeal, they would have filed an appeal.
Was there any occasion before the trial court where evidence was adduced?
Plaintiff was called. He gave examination in chief, but no exhibit was there. No document was exhibited. So, it is not proper to pass an order without relying on a reliable document.
And now you are evicted from your house.
Yes. Now we are staying outside our house. Our house is under lock and key. Some of our family members were an aged person. Some of them are small children.
So by virtue of what authority were you occupying
Because
the present suit land?
initially we verbally approached the local council concerned. So they advised the appellants to build a house. So we built a house, and thereafter we applied for issuance of necessary land passes. So our application was still under process. It was processed. House site plan were made in our favor, but before land pass was issued in our favor, the
eviction suit was filed.
Yes, the eviction suit was filed.
Okay, then what other submissions?
Lordship, if I may be allowed to submit this citation. Your Lordship, Lachi Tiwari, in this case the Apex Court, under para number 4, may I read the Lordship? The mere narration of facts would suffice to focus attention on what point It is involved in this appeal. The petitioner obtained Rule Nisi in 1976 and waited for 7 years for its being heard. Suddenly, one day, the High Court, consistent with its calendar, fixed the matter for hearing on April 21, 1983. The petitioner had taken extra caution to engage 3 learned counsels. We fail to see that what more can be expected of him. Further, we fail to understand that what more step would have taken in the matter to avoid being thrown out of unheard. In Rafiq and another versus Munsil and another, this court succinctly brought out this aspect, says the court. The disturbing feature of the case is that under our present adversary legal system, where the parties generally appear to their advocates, the obligation of the parties is to select his advocate, brief him, pay the fees demanded by him, and then trust the learned advocate to do the rest of the things. The party may be a villager or may belong to a rural area and may have no knowledge of the court's procedure. After engaging a lawyer, the party may remain supremely confident that the lawyer will look after his interest. At the time of hearing of the appeal, the personal appearance of the party is not only not required but hardly useful. Therefore, the party, having done everything in his power to effectively participate in the proceedings, can rest assured that he has neither to go to the High Court to inquire as to what is happening in the High Court with regard to his appeal, nor is he to act as a watchdog of the advocate. That the letter appears in the matter when it is listed. It is no part of his job. Again, in Goswami, Krishna, Murarila Sharma versus Dan Prakash and others, this court reiterated this very principle, and that squarely applies to the facts of this case. On this short ground, we allow this appeal. Set aside the order of the High Court dated April 21, 1983, as also the order refusing to recall the earlier order dated May 2, 1983, and restore the civil rule to the file of the High Court to be disposed of by the High Court on merits consistent with its calendar. Another one, let's see, Malkiyat Singh and another versus. The relevant portion is at page 3. Page 3. It is not disputed in the present case that on March 15, 1974, when Mr. Adhia, advocate, withdrew from the case, the petitioners were not present in court. There is nothing on record to show as to whether the petitioners had the notice of the hearing of the case on that day. We are of the view when Mr. Adhia withdrew from the case, the interest of justice required that a fresh notice for actual date hearing should have been sent to the parties. In any case, in the facts and circumstances of this case, we feel that the party in person was not at fault and, as such, should not be made to suffer. There is another. In Devendra Swami, para number 5. Having heard the learned counsel for the parties, we are satisfied that in the facts and circumstances of this case, a division bench did not err in condoning the delay in filing the appeal. The lawyer engaged by the respondent corporation was holding the papers and did not inform the corporation of the decision in the writ appeal. The corporation, having left convinced of the default on the part of the lawyer, removed him from the panel of the corporation and engaged another counsel through whom the writ appeal was filed. Sufficient cause for condoning the delay in filing the appeal was made out. Discretion to condone delay under Section 5 of Limitation Act has been judiciously exercised by the High Court, placing reasons on record and is not open to interference by this court. Another one, Ajay Singh and another. Para number 3. The district judge observed that the counsel for the appellant was clearly negligent in the performance of his duties, and his mistake in filing the appeal before the senior subordinate judge instead of the district judge could not be characterized as bona fide. and consequently it was held that there was no sufficient cause for the condonation of the delay in filing the appeal. The appeal was accordingly dismissed as being barred by time. The para 4, the approach of the district judge in this matter cannot but be branded as wholly untenable and erroneous. The appellant, being a person untrained in law, cannot, in the absence of any bona fides, be penalized for the mistake of law committed by his counsel in filing the appeal before the wronged forum. In the present case, there is no warrant for holding that the mistake committed in filing the appeal before the senior judge was anything but bona fide. The last one was collector land acquisition versus FPG and others. Para number 3. The legislator has conferred the power to condone delay by enacting Section 5. Any appeal or any application other than an application under any of the provision of Order 21 of CPC of 1908 may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application within such period of the Indian Limitation Act of 1963 in order to enable the court to do substantial justice to parties by disposing of matters on merit. The expression sufficient cause employed by the legislature is adequately elastic to enable the courts to apply the law in a meaningful manner, which subserves the ends of justice, that being the life purpose for the existence of the institution of court. It is common knowledge that this court has been making a justifiable liberal approach in matters instituted in this court, but the message does not appear to have percolated down to all the other courts in the hierarchy. And such a liberal approach is adopted on principle, as it is realized that 1. Ordinarily, a litigant does not stand to benefit by lodging an appeal late. 2. Refusing to condone delay can result in a meritorious matter being thrown out at the very threshold and cause of justice being defeated. As against this, when delay is condoned, the highest that can happen is that a cause would be decided on merit after hearing the parties. 3. Every day's delay must be explained. Does not mean that a pedantic approach should be made. Why not every hour's delay, every second's delay? The doctrine must be applied in a rational, common sense, pragmatic manner. 4. When substantial justice and technical considerations are pitted against each other, cause of substantial justice deserves to be preferred for the other side, cannot claim to have vested right in justice being done because of a non-liberal delay. 5. There is no presumption that delay is occasioned deliberately or on account of culpable negligence or on account of mala fides. A litigant does not stand to benefit by resorting to delay. In fact, he runs a serious risk. It must be grasped that judiciary is respected not on account of its power to legalize injustice on technical grounds, but because it is capable of removing injustices and is expected to do so. So in my case, Lordship, since the appellants were not aware of the necessity of filing, they did not prefer the appeal in time. Your Lordship, if this application is not allowed, they will be thrown out of their house. They will have nothing. They have nowhere to go. Even at present, they were staying outside their house since their house were put under lock and key. So I pray this honorable court to allow this application, even though the delay may be, the number of days delay may be much, but there is a sufficient cause because they were not informed at the relevant time to file an appeal. Because they were an ignorant person, having no knowledge regarding the proceedings of the court. In fact, if they were informed about the necessity of filing an appeal, they would have filed it. If they were told to file a review petition, they proceed. And if they were informed to file an RFA before this district court, the thing was done. They left nothing undone if they were informed. But now, since they were not informed about the necessity of filing an appeal before the High Court, this delay has been caused.
Okay. Yes, any other objection?
Yes, my lord.
Yes.
If I may take your lordship to the page 6 of the impugned order in the appeal, in the main appeal.
Yes.
My lord, the last paragraph at the bottom portion. The respondents number 1, 2 and 3 appeared in person in this court on 17/10/2000. Page 6.
Page 6 of the appeal memo.
Appeal memo case. This is the impugned order. In eviction suit number 4 of 2019. It's in the small Roman numbers, madam. Small Roman numbers at the beginning of the
Oh, okay.
the bottom portion.
Yes, yes.
The respondents number 1, 2 and 3 appeared in person in this court on 17/10/2019 and are directed to avail the service of legal aid counsel. The respondent number 1, 2 and 3 have however failed to appear before this court on any subsequent court dates in person or through a counsel despite notice having been issued and having been clearly informed to do so in person. The suit was then proceeded with ex parte and issues were framed on 12/2/2020. The counsel for the plaintiff also submitted his examination in chief, and since no one appeared for the respondents number 1, 2 and 3, no cross-examination was conducted. So, my lord, the respondents have clearly stepped on the rights, my lord. They were clearly informed by the court that they had to engage a counsel, or if they don't have money to engage counsel, approach a legal aid counsel. And they refused to do so. And subsequently, this eviction suit was disposed of, and they were directed to leave the property. Subsequently, they engaged a counsel and they filed a review petition, which clearly shows that, my lord, they are aware of their rights. And the review petition was dismissed.
Yes, you appeared before the
Yes, Your Lordship.
trial court.
They appear in person
1710.
before the, yes, 1710,
And you were directed,
2019. They were informed to engage counsel, and they were even informed to engage a legal aid counsel.
Yes.
Yes,
But they have not
that's
done
correct, Your
anything.
Lordship. They appear in person, but thereafter, instead of engaging a counsel at once, they collected some documents from the concerned department, that is Revenue Department, because they have filed an application for issuance of necessary land passes, so they applied Revenue Department. So in the process, their case has been already, in the process, their case has been proceeded ex parte, and ex parte judgment was pronounced. And thereafter, they engaged a counsel who in turn filed a review petition on their behalf. Lordship, there is no malified intention in this regard. If we, the proceedings of the court were annexed in this appeal memorandum.
Then further at page 7 also,
Yes.
it is also seen that the respondents 1 to 3 have not responded to any of the notices and orders issued to them by the Director Land Revenue to state their rights in building houses and occupying the said lands.
Your Lordship, the
So
daily,
it appears that you have been negligent from the very beginning.
Your Lordship, the day-to-day order was annexed. Is annexed in the appeal memorandum. Your Lordship,
I'm dismissing the IA.
as I have said,
Yes.
they were an ignorant person. They do not know the
You
power-
have
they
been
do not know the
given
power of the
enough
court,
of
even the power of the
opportunities. And here also in the present petition also, in the present IA also, 700 something days, that is a big, big number.
yes, yes,
Nearly
that's-
2 years.
yes. Within those days,
And that also is
Yes.
not explained.
within those
properly.
days, Your Lordship, within those days, their previous counsel was pursuing the execution case, which was going on.
Besides the execution, this is minus the litigating period. This is minus the period spent in litigation and COVID. Even then, it comes up to 775
Yes.
days.
Within
So
those
where
days,
is the explanation for that?
the counsel was pursuing the execution case.
Pursuing for nearly 2 years, how can that be?
Yes.
The present application, right? The present application. Please write. The present application filed under Section 5 of the Limitation Act 1963 has been filed for praying for condonation of 1,883 days in filing the connected appeal against the order and decree dated 26/2/2020 passed by the learned Senior Civil Judge 3 in eviction suit number 4 of 2019, as well as the impugned order dated 13/7/2023 passed by the learned Senior Civil Judge 4 in CMA number 416/2023 arising out of eviction suit number 4 of 2019. Stop. Learned counsel for the appellant, Mr. Such and Such. Stop. Your name. The applicants have stated that the impugned order and decree dated 26/2/2020 was passed ex parte against the applicant, but it was not known to them immediately. Stop. Moreover, no proper steps could be taken by the appellant/applicants due to the COVID-19 pandemic. Stop. It is also stated that after getting the knowledge about the said order and decree dated 26/2/2020, the appellants/applicants were advised by their counsel to prefer a review petition. Stop. Accordingly, a review petition number 8 of 2021 was filed on 9/3/2021, and the same was disposed of on 8/4/2022. In fact, the review petition filed by the applicant was dismissed by the learned trial court by holding that the grounds taken in the said petition were not errors apparent on the face of the record. Stop. Hence, apart from the time taken for filing the said review petition during the COVID-19 pandemic, the court proceedings of the review case took a further number of 395 days. Stop. Para. Since the review petition filed by the applicant was dismissed by the learned trial court, the engaged counsel of the applicant engaged another counsel, and accordingly an appeal was filed before the district judge. Stop. However, the said appeal, RFA number 20/2022, was dismissed due to lack of pecuniary jurisdiction, vide order dated 18/8/2022 and order dated 17/11/2022 passed in CMA number 429/2022 arising out of RFA 20/2022. Stop. Therefore, a number of 132 days were taken. In fact, a number of 132 days were taken by the said two councils for preparation of the said appeal, and another 91 days was taken for prosecuting the said CMA number 428/2022 arising out of RFA 20/2022. Stop. Para. It is further stated that when RFA 20 of 2022 was dismissed, the applicant was again advised to file an application under Order 9, Rule 13 CPC for setting aside the ex parte order and decree dated 26/2/2020. Stop. Accordingly, an application, that is i.e. CMA number 416/2023 arising out of eviction suit 4 of 2019 was filed on 12/6/2023. Stop. However, the said application was again dismissed by the trial court on 13/7/2023. Stop. Thereby, a number of 207 days were taken for preparation of the said application, and another 31 days were taken for prosecuting the said application, i.e. CMA 416/2023. Stop. Para. The applicant states that they did not have any knowledge of court proceedings and they are ignorant laymen, and as such they were completely depending upon their counsel. Stop. However, no advice was given by their counsel to file an appeal before the High Court, and instead he was contesting the connected execution case while the applicants were blindly depending upon the counsel. Stop. Para. It is also submitted that no advice was received from the counsel regarding filing of an appeal. Stop. However, while they were... Can you please either switch off your phone on or take it outside? Since no advice was received from their counsel, the applicants were not aware of the necessity of filing an appeal. Stop. However, when they were peacefully occupying their respective houses within the suit land, they were evicted from their houses, and their houses were locked from outside, and they have not been allowed to enter their houses since 3/6/2025 till date. Stop. Para. Thereafter, they approached the present counsel, who in turn advised them to file an appeal before this court. Accordingly, the applicants have started the process to file an appeal before this court, and necessary documents were applied for from the Department of Land Revenue and Settlement, Government of Mizoram, and the same was issued to them on 26/6/2025. Stop. Para. After obtaining all necessary documents, the newly engaged counsel of the applicants took some time to study the case, and after obtaining certified copies of the impugned orders on 21/7/2025, the present application has been filed on 23/7/2025. Stop. During this entire process, a total number of 1,883 days delay has been caused. Stop. The Learned Counsel for the applicant further submits that excluding the COVID pandemic and the period spent litigating before the trial court, the period of delay is 700. How much?
775 days.
775 days. Stop. Para. Learned Counsel for the applicant has also relied on the cases of. You just cite these cases, okay, later, to substantiate his contentions, to substantiate his conditions that, to substantiate his contention that that the applicants should not be made to suffer, because of the default or negligence of his counsel, and the matter should be heard on merit. Stop. Learned Counsel therefore prays that the present application may be allowed and the delay of 1,883 days may be condoned. Stop. Para. Learned Counsel for the respondent number 1. Learned Counsel for the respondent number 1, Sri such and such, has filed his written objection and has submitted that the statement made by the applicant that they were unaware about the passing of order dated 26/2/2020 passed in eviction suit 4 of 2019 is false, as they were served copies of the said order immediately at the time of passing of the said order dated 26/2/2020. Stop. It is also false that the applicants could not take proper steps, as they had already engaged a counsel who filed review application number 8 of 2021 in eviction case number 4 of 2019, which clearly shows that they were aware of the eviction order passed against them. Stop. Learned Counsel also states that the applicants had appeared in person before the trial court, but thereafter they did not enter appearance and did not engage any counsel to represent them, nor did they adduce any evidence. Stop. And the same is clearly reflected in the impugned judgment and order dated 26/2/2020. Stop. Para. Learned Counsel for the respondent 1 also submits that in the number of days taken for filing the review, RFA and the CMA applications before the learned trial court have been stated to be 395 days, 132 days and 207 days respectively, amounting to a total of 734 days, for which no explanation of any kind has been stated in the application. Stop. The applicants have merely stated the number of days without giving any reasons for the delays in filing them. Stop. Para. The statement that the applicants had no knowledge about the court proceedings and that they were completely depending on their counsel has also not been corroborated by annexing any statements or acknowledgements from their previous counsel. Stop. The statement made by the applicant regarding the inaction or actions of the counsel cannot be a valid reason for cannot be a valid reason to condone the delay in filing the present appeal. Stop. Para. The statement made by the applicant that they had sought for information regarding the LSC number 3194 of 1985 has no relevance in the present application, as the applicants have not stated or annexed any copy of their RTI application before the authorities, and the date on which such application was submitted or the number of days taken for the process of such RTI explanation has also not been stated. Stop. Learned Counsel further submits that the remaining days after excluding the period of after excluding the COVID period and the period spent during litigation before the trial court is unaccounted for, and no reasons whatsoever are mentioned for the delay during the unexcluded period. Stop. Learned Counsel therefore submits that the present applicants have failed to show any sufficient cause within the meaning of Section 5 of the Limitation Act to justify the inordinate delay, and the delay is caused solely due to the negligence of the applicants, and therefore prays that the present application may be dismissed. Stop. Para. This court has duly considered the submissions made by the counsels for the opposing parties and has also perused the judgments and the records. Stop. Upon going through the impugned judgment and order dated 26/2/2020, passed in eviction suit number 4 of 2019, this court has observed that the respondents number 1, 2 and 3 / applicants had appeared in person before the trial court on 17/10/2019, and they were directed to avail the service of a legal aid counsel. Stop. The applicants, however, failed to appear before the court on the subsequent dates either in person or through counsel. Stop. It is seen that issues were also framed on 12/2/2020. Stop. But none appeared for the applicants, and they also did not adduce any evidence. And hence, the evidence of the plaintiff was not disproved at any point of time. Stop. According to the learned trial court, it is stated in the judgment and order dated, according to the learned trial court, as stated in the judgment and order 26/2/2020, it is also seen that the applicants had not responded to any of the notices and orders issued to them by the Director, Land Revenue and Settlement Department, IZOL, to state their rights in building the houses and occupying the said lands. And they had not responded to any of the show cause notices issued by the Land Revenue and Settlement Department. Stop. This court is also of the view that even after excluding the COVID period and the period spent by the applicants while preferring the various applications before the trial court, the review petition, the RFA and the CMA, there remains a period of 775 days which remains unexplained. Stop. The applicant has not been able to show what transpired during the 775 days, which is a substantial number of days, as it is nearly 2 years. As it is nearly 2 years. Stop. The reason given by the applicant that the delay was solely due to the wrong advice given by the counsel does not hold any water, as the unexplained days of 775 days has not been substantiated in any manner by the applicant in the present application. Stop. Para. In view of the discussion above, this court is of the view that the applicant has not been able to show sufficient cause for delay of 1,883 days or even 775 days, and therefore this application, being devoid of merit, is dismissed. Yes.
All right, Your Lordship.
Yes. in the main case, RFA 27, you say in view of the order passed in IA 112 of 2025, the present petition stands dismissed. Yes.
Item 9.
No, please, your lords. In this case, my lord, I have taken steps upon the sole respondent on 17/9, and the card is not yet returned. We may wait for
Still
service
awaited.
report.
Yes. Should we wait or you want to take fresh steps? Wait.
Wait for
Yes.
the next 30
Don't-
days.
Learned Counsel, Mr. Victor L. Raut is present for the appellant. Stop. The office note dated 21/10/2025 indicates that the AD card in respect of the sole respondent is still awaited. Stop. Accordingly, list after 3 weeks.
Yes, my lord.
3 weeks awaiting service of notice on the response.
In the IA, my lord, the stay may be continued.
Okay, in IA 166 of 2025, you say learned counsel for the applicant is present. Stop. The interim order passed earlier shall continue till the next date.
Much obliged.
Item 11.
May it please your lordship? Your lordship, in this case, we have received the objection from the opposite parties. However, if I may be allowed 3 weeks time to file our objection.
Objection or reply?
Reply, your lordship. The departmental counsel, Mr. Johnny, his relatives are having heart surgery today.
Condonation. This is condonation application, and objection is already received. So, what more reply you want to make?
That is the instruction I obtained, lordship.
Okay. Senior counsel is not there.
Yes, lordship.
Okay.
Mr. Johnny.
Learned counsel, Mr. Sanisaj is present. He has submitted that the written objection has been received from the respondents. Stop. And he has prayed for listing the matter when?
After 2 weeks, lordship.
After 3 weeks, as the leading counsel, Mr. Such and Such,
Mr. Johnny that anymore.
such and such, is indisposed.
Yes, lordship.
Is indisposed. Stop. He has also prayed that he may be allowed to file a reply to the written objection, if so advised. Stop. Accordingly, list after 3 weeks, learned counsel for the appellant, Miss Such and Such, is present.
Respondents, yes.
Item 12.
Oh, sorry, learned counsel for the respondent.
My lord, in item 12, I had filed my objection to the IA for the sole respondent. If the matter may come up after 2 weeks, my lord.
Learned counsel, Sri Such and Such, submits that the affidavit in opposition on behalf of the respondent, sole respondent, on behalf of the sole respondent, has been filed, and therefore the matter may be listed after
2 weeks, my lord.
After 2 weeks. So, prayer is allowed. Learned counsel for the petitioner is present and has no objections. List after 3 weeks.
Obliged.
Item 13.
In this matter, my lord, I had filed my affidavit with respect to the respondent number 7, the insurance company.
7.
Lordship,
1 to 6.
in this case, I have already instruction from respondent number 1 to 5.
1 to 5.
Bakalan has not yet executed.
Not yet filed.
Yes.
Lordship, I am for the respondent number 7, NIC, insurance company.
Okay. Learned counsel for the appellant such and such present. Stop. Learned counsel Sri such and such enters appearance for respondent number 1 to 5. Respondent number 1 to 5, okay? And prays for how much time?
2 weeks maybe.
Or prays for 2 weeks' time to file his Vaklatnama as well as objections. Stop. Learned counsel, Mr. Such and such enters appearance for respondent number 7.
Yes, Lordship.
Number 7. Are you also filing
Yes,
objection?
Lordship. Same prayer.
Okay. He has also prayed for 3 weeks' time to file his objections. Stop. Prayer is allowed. Please stop to 3 weeks.
My lord, with respect to respondent number 6, my lord, AD card may be awaited.
Yes. The AD card in respect of respondent 6 is still awaited. Stop. Yes, after 3 weeks we'll see.
Oblige.
Item 14.
May please, Your Lordship, I'm for the respondent number 1, and if we may be given another 1 week time to file our counter affidavit, my lord.
To file counter.
Yes, my lord.
Learned counsel for the
Lordship, as a
yes.
last chance, if possible, because at the learned court, trial court, it is a stage of judgment and order. So, if
what is
judgment
this IA for?
This IA 177 is for amending the pleadings in the FAO.
Oh, there's a connected FAO.
Yes, my lord.
So you want to amend the pleadings
Yes, my
here?
lord.
Oh, I think this can be allowed. It is just for they have
Inserting one ground.
just
It
to
is at page
insert
4.
order 22 for preferred offence omitted to take violation of order 22 of the CPC. So you are going to object against this, against the amendment?
Yes, my senior counsel is indisposed today, my lord. So,
So
that
can
is
we
the
list it
instruction.
next week? I think this can be disposed of
Yes.
next week.
Yes,
Learned counsel for the applicant / appellant, MS such and such. Stop. The learned counsel, Sri such and such, appearing for the respondent number 1, prays for some time to file the counter affidavit. Stop. It is seen that the present IA is filed praying for amendment of the pleadings in the connected FAO number 4 of 2025, and the prayer of the applicant is to insert one more ground taking the what is that ground you want to take?
Order the learned trial court, which is at page number 4, para number 3.
Oh, you just want to amend the prayer portion?
Yes, my lord.
What did I say last line? One more ground in the prayer portion. Stop. And therefore this matter, this IA may be listed next week. Next week is okay.
yes, my lord.
Next week as a fixed item, and an endeavor shall be made to dispose of the same on the next date. Yes.
DP obliged.
That's
Item 15.
Yes.
My lord, in the last clause, due to notification.
Yes. Since this is not pertaining to the same accused,
Yes, ma'am.
it's not pertaining to the same accused. Okay. Yes. Who's appearing? PP, you're appearing?
No, Lordship, I'm appearing on behalf of my senior, the departmental counsel, Mr. Johnny. He's indisposed today.
Oh, okay, the customs department.
Yes,
Custom Department.
Moreover, Lordship, we have not yet received the bail application in this.
My lord, it is,
Some case.
after authorization, we have duly received copies in the petition, my lord. It is after one page number.
Copy of the application was served to counsel for the respondent.
Lordship,
Anyway, you supply another copy. It's okay.
If they require, okay, we can furnish, my lord, soft
Yes.
copy. As per their demand, previously we have served them 2 copies.
2 copies already.
They have taken, they
You check
demanded
up.
2
You
copies.
check
no,
up.
In case of their misplaced, okay, we can give them soft copy.
Lordship, if I may be allowed to receive another application, even in soft copy as well, it's okay.
Because in the office note of office note of 25/9/2025, it states that the copy of the application was served to the counsel for the respondent. This is dated 25/9/2025. Of course, signature is not there. Receipt signature is not there. Do you have any receipt?
They, our normal practice is, my lord, we make that format and they receive and put their signature.
And then it is filed before the court, isn't it?
Yes, my lord.
The receipt is given and then it is filed
Separate
before the
receipt is
court.
not.
No, not separate receipt, but you just take up, let him check this. Just see whether your signature is there or not. Oh, in the petition, at the back side, na?
In the petition page number 1, after 133.
This one? No, this is for petition. It is not there, no? Yes. Receipt is there. Mr. Johnny L. Tokwang. Yeah, he is the
Departmental Counsel.
departmental counsel. So he has received.
Lordship, I was instructed that after the receipt, after the petitioner supplied the extra copies, it was taken back by the counsel of petitioner.
No,
Due
my
to
lord.
some
Yesterday in the
mistake,
evening.
they say.
Taken back.
Yes, Lordship.
No, my lord.
From the
No, what's the problem? Okay, serve one more copy.
Okay.
It's for your own good.
Yes, my
Yes.
I told him, and yesterday evening, Johnny himself called me up and requested me to give soft copy. I told him, okay. Johnny himself told me that it was unfortunately misplaced.
Anyway, you just serve him a copy. It's okay. Heard learned counsel for the petitioner, Mr. Such and Such. Stop. Learned counsel, Ms. Sri Such and Such, appearing on behalf of the appearing on behalf of Mr. Johnny L. How do you pronounce this? Tokwang. Yes, counsel for the customs engaged counsel, no, panel counsel for the customs department submits that a copy of the bail application has not been received. Stop. The receipt dated 23/9/2025 enclosed along with the application shows that the copy was received by the counsel. Stop. However, the petitioner's counsel is directed to serve another copy to the counsel for the respondents. Today, you can give today.
Soft copy, my lord. Soft copy. Hard copy, it will be.
Hard copy within 3 days.
soft copy today itself.
No, and the hard copy, 3 days. Within 3 days. By Monday.
It will be possible, but for Xerox, so many expensive, because as per the demand in the previous, we
The
have.
sooner you serve, the sooner your petition will be taken up. So Tuesday, Learned Counsel for the
Okay.
Ministry shall serve copy of the bail application to the Respondents' Council by Tuesday, by next Tuesday. That is 28/10. Stop. And the matter, when can you obtain the case diary, the records? 1 week?
Lordship, if your Lordship permits 2 weeks, because it will have to be furnished back to the department, and a Parawas comment will be received again.
No need for Parawas comments in bail application. You just produce the records,
Yes.
the case diary. And thereafter, list this matter after 10 days, on the next date, the Learned Counsel for the Respondent shall produce the updated case diary. Yes.
Blood, madam.
Much obliged.
We'll continue at 2.
Your Worship, this next item, if this matter can be listed after
16,
1 week, yes.
16.
It's the same matter because it was listed day before yesterday. Due to the notification, there was some confusion.
Item 16 on the prayer of the Learned Public Prosecutor, list the matter after 1 week. After 1 week, in order to enable the PP to obtain the case diary. Yes. Then
Your Lordship, in the last court date, the scanned copy of the TCR was already called for in this matter.
Oh, okay. Then don't say anything. Just say list after 1 week.
I'm duly obliged.
Yes.
If I may
Then-
also make
yes,
one
yes,
mention, my lord.
mentioning,
This item number 17, my lord. So, my lord, if I may be allowed to make a reply to the application filed by the petitioners, sorry, by the applicants.
By the applicant.
Yes, my lord, and I may be given 1 week, my lord. And also, Mr. 2
Okay.
weeks, my lord.
Heard.
Okay, I'll take few days, my lord, and then the matter
10
can come
days.
up next.
10 days. You take 10 days.
10 days, certainly, my lord. And also, Mr. Malhotra is not there, so
Mr. Malhotra is for the petitioner.
yes.
Okay. And you are for?
I'm for the respondents number 6 to 17.
Learned Counsel Judge responded appearing for the respondents number 6 to 17. Prays for 10 days time to file a reply to
The application filed by
the application
interveners.
filed by the intervener. Stop. Prayer is allowed list after 10 days. The Learned Counsels for such and such, you just give their names, okay, are present. Yes.
Obliged, madam.
And item 18.
Yes, my lord.
Yes.
I'm extremely sorry to say, my lord, if this matter may be, if we may be accommodated for the day, and if this matter may be fixed for 7th of November.
Learned Counsel for the, you're for the petitioner?
My lord.
Comes for the petitioner, such and such, who makes a mention for listing the case on 7th.
My lord.
On the 7th of November for hearing, and the said prayer is not objected to by the Learned Counsel for the respondents. Stop. List on 7th November for hearing. Yes.
Deeply obliged.
Part 2, item number 5.
May it please, Lord.
Yes.
Now, the present appeal, RFA, has been filed challenging the impugn judgment passed by Delani Senior Civil Judge Court, wherein The learned lower court lordship dismiss my suit, my lord. And the impugned judgment is in case hearing lordship. So actually, page 63 of the paper book, lordship.
63.
63 of the paper. This is the impugned judgment of the land trial. And the operative part lordship is at page 77, 78. Hearing lordship, the land trial court at page 77, para number 31 lordship.
Yes.
In deciding the issue whether both the plaintiff and defendant entitled to absolute ownership of land allotted to them by Zoluang Village Council in the year 1994 and occupied by them till today. Then it is decided also. Both the plaintiff and defendant have been allotted a plot of land by the Zoluang Village Council in the year 1994. They occupied land separately without any encumbrances until the year 2006, when the dispute arose in there. It was because of action of the pro forma defendants. The pro forma defendants has committed a grave mistake by issuing the LSC number so in the name of plaintiff, which included the whole area occupied by both the plaintiff and the defendant. Therefore, the pro forma defendants are directed to issue separate LSC to both the plaintiff and defendant without unnecessary delay in respect of the land occupied by them at so and so, so and so. From the place so and so, so and so. So, now, what aggrieved the appellant here in lordship is the bifurcation of my land. Actually, I am the owner of a legitimate, duly issued land pass in respect of the dispute area, whereas the plaintiff has no document. So, actually, now the present issue before lordship today is to decide whether I, having a document, is in better title to the land or to the plaintiff, the defendant, the respondent here, the respondent defendant, who has no land document in respect of the disputed property.
But trial court has said that both defendant and plaintiff had been allotted plot of land in the year 1994.
Yes, my land has been directed to be split into two different LSC. Has to be bifurcated also into two. While the defendant, my lord, the respondent is not having any document of title. So actually it's a
let us see the evidence.
Evidence, yes. My plain lordship begins from page number 1 in the paper book. This is the copy of the plain submitted by me before the land trial.
You had filed for eviction of the defendant.
Yes. The story goes like this also. I was living in the suit land, my lord, from 1999 onwards. And thereafter, in 2006, lordship, the Revenue Department of the state government issued to me a LSC, Land Settlement Certificate, as per law, lordship, which is the highest form of ownership that can be given to an individual by the state government, my lord, Land Settlement Certificate. And that is also issued as per law. There is no dispute regarding that, my lord. There is no dispute regarding that I was issued a LSC for the whole land, number one.
In 2006.
2006. And thereafter, yes, Your Lordship.
Yes.
Thereafter, the defendant, my lord, also built a house within my land covered by that LSC, my lord, without having any title, my lord, any document issued by the review department.
When? Which year?
That was that he built his house in, if I'm not mistaken, 2003, my lord. 2002. Yes, maybe.
2003.
So, so he was not having any land passports. And thereafter, my lord,
Then?
thereafter, I approached the revenue department in the state government, my lord, to make an order for evicting him, my lord, from the land where he was residing in. And the revenue department also used to detail some surveyors, from time ago, maybe 2-3 times, my lord. But only one surveyor happened to reach the disputed land and took measurement of that also. But no fruitful order was issued till date. So no order never came up. So having no other option, also, I filed the present eviction petition before the court. I filed the eviction petition for evicting the defendant, the respondent. And my plaintiff is at page number 1. And
then written statement?
Yes, Lord. There is no written statement as such.
Okay.
And he submitted some kind of a plain paper before the judge. That actually and technically was not a valid pleading. So no verification, no affidavit, no valuation of so-and-so, no counterclaim so-and-so. Only a simple paper. A simple letter was presented by the defendant to the court. So technically, Lordship, there was no contest, Lordship, by way of filing pleadings by the defendant, Lordship. Whereas I now have filed a duly verified, supported by affidavit plaintiff. That has never been questioned, madam. So, regarding my plaint, there is no question. Regarding its technical defects or whatever, nothing is there. In my plaint, I have enclosed at page number 5 also.
This is the LSC.
LSC, Land Certificate of Land Settlement Laws. This was issued as per law, following due process laws. This lordship it is not, my lord, in dispute that this was duly issued to me. Duly issued to me following due process of law by the Revenue Department. It is not in dispute, my lord. This, till date, my lord, this certificate My Lord. This land settlement certificate issued to me by the competent authority, Lordship, of the Revenue Department covers the whole area. Number one, it covers the whole area, including the residential area, my Lord, of the defendant, Lordship. Number two, they Lordship. Next point, they never challenge. This is my LSC till date. It has never been challenged before any competent authority, including Court of Law. Lordship. This LSC has never been challenged till date.
Okay.
It attained finality, Lordship. Attained finality till date. Lordship.
Yes.
So I enclosed all the necessary annexures. And the next point also, to put in a simple term, the defendant and on framing of charges, framing of issues by the court, taking that there are some contesting issues, some conflicting interests is there, even though the simple paper of letter, Lordship, was accepted against my objection, my Lord, by the trial court as a written statement, my Lord.
Where is that page?
It is not supplied in the. I think it's in the separate.
It is not in the records.
In the record.
It is not in the paper book, my lord. But I think on the last occasion, my lord, I think Justice Murley had identified it. It's in the record, my lord.
I think
It's
in the trial court
It's
record.
in the trial court's record. It's a Mizo vernacular
And it's
handwritten
translated
letter.
therein, Lordship. I have got it translated. I think it's supplied to me.
I don't have a copy of this one or the Mizo vernacular. It has not been provided to us.
Okay.
Let that be.
Anyway, that was taken as a WS.
WS, but actually it's not a WS because it is not supported by verified as per the Order 6 Rule 15 of the CPC. And no valuation is there. Order 6 Rule 15, it has not complied with the requirements of Order 6 Rule 15 of the CPC, pleadings, rules of pleading. If I may read Order 6, Rule 15, Madam. CPC. It says, Order 6, Rule 15.
Yes, verification of pleadings.
Verification of pleadings. If I may read, Lordship. Save as otherwise provided by any law for the time being in force. Every pleading shall be verified at the foot by the party or by one of the parties pleading or by some other person proved to the satisfaction of the court to be acquainted with the facts of the case. Number 2, the person verifying shall specify by reference to the numbered paragraphs of the pleadings what he verifies of his own knowledge and what he verifies upon information received and believed to be true. Number 3, The verification shall be signed by the person making it and shall state the date on which and the place at which it was signed. Number 4, the person verifying the pleading shall also furnish an affidavit in support of his pleadings. Now, my lord, none of this has been done in respect of the present case, wherein that simple letter submitted by the respondent defendant, my lord, was accepted wrongly, lordship, by the learned trial court. That cannot, my lord, sustain in the eyes of law. So, technically speaking, my lord, technically speaking, there is no pleading on behalf of the defendant respondent in the present case, technically speaking. So, it is a case wherein there is no pleading on the part of the defendant. In that case, my lord, they have no case, my lord. For that, my lord, if I may place reliance on some judgments of the apex court law, if I may kindly be allowed to rely on.
There are some judgments here. Maybe you had supplied earlier. 2012 8 SCC 148.
That actually, my lord, may be done earlier, but now I'll, before that, my lord, rely on some other citation, lordship. 2011 3 SCC 436, lordship. 2011 volume 3 SCC 436. The relevant paragraph, lordship.
Yes. Pick para.
Paragraph number 55. 55.
Yes.
If I may read, lordship.
Yes.
Relief not claimed cannot be granted. Pleadings and particulars are required to enable the court to decide the rights of the parties in the trial. Thus, the pleadings are more to help the court in narrowing the controversy involved and to inform the parties concerned to the question in issue, so that the parties may adduce appropriate evidence on the said issue. It is a settled legal proposition that, as a rule, relief not founded on the pleadings should not be granted. Therefore, the decision of a case cannot be based on grounds outside the pleadings of the parties. Now, my lord, in the present case, there is no pleading. That means they cannot have the respondent defendant, my lord, cannot be given any relief at all. If given at all, that will be beyond the pleadings, as far as they are not having any pleading at all. Any legally valid pleading, they do not have it also before the court. So, actually, the learned trial court, due to reason best known to him also, granted relief which is not claimed in the pleading also. That is not allowed in law, man. It is a settled position of law that giving relief beyond the pleadings cannot be allowed in law.
What is this page 13A in the paper book? Page 13A. A letter, this is a letter written to the court.
13A.
Page 13A. In the paper book, do you have the paper book?
13 is there, my lord. 13
Page
is not-
13, then there's one, page 13A. Written to the Senior Civil Judge 1,
Maybe that was the one
Aizawl
which is
District,
treated as a-
Aizawl, Mizoram.
It later was enclosed therein, but which maybe this copy, my lord. This is translated.
Acha, the subject is Eviction Suit 1 of 2014.
I think so.
Regarding
Yes.
reference number 91 slash
Yes.
Senior CGA. This
Mine.
is the one then. It is in the paper book, page
Yes, I think so.
13A.
It is not
Translation.
there initially, and translation is later supplied to me, lord. That is why I have it as a loose paper here, my lord. So, yes, if your lordship have got it, that one, has got it, and
It is already there.
yes. Now, this cannot now, my lord. If your lordship kindly take a look at that paper, lordship. Be treated as a valid pleading, lordship. There is no verification, there is no proper addressing, there is no proper paragraphing, there is no proper referencing, there is no nothing verification, no, there is not supported also by affidavit as required by Order 6, Rule 15 of the CPC laws. And there is also no counterclaim, my lord, so as to be granted relief in respect of, in terms of the impugned judgment. Now, by this impugned judgment which I have challenged today, my lord, he was granted relief, my lord, relief of slicing out portion of my land to him, my lord. There is no such prayer herein, my lord. In the petition, in the alleged written statement which lordship, which slip in there in page number 13A, lordship. If I'm not mistaken, it is 13A, is it, lordship?
Yes, it is 13A. It is a translation, yes.
My lord. So, in this paper, lordship, nothing is there. It is not a valid, legally valid document in terms of Order 6, Rule 15 of the CPC laws. It cannot be accepted as such laws. As your lordship knows very well, the trial court are not writ court. They cannot do whatever they want. They have to be bound by the rules of pleadings and rules of procedure laws. So they have to adhere to all these provisions of CPC, my lord. So there is also no payment of ad valorem court fee also. Nothing is there, my lord. It's a simple letter that cannot now be accepted as a valid, legally valid pleading.
Okay, so that is one ground.
One ground.
And then?
Number two, my lord. They do not have any legally valid document of land pass. They do not have any legally, validly issued land pass in respect of the suit land. Whereas, I have a duly issued land settlement certificate which lordship is not challenged till date, lordship. It has not been challenged till date, lordship. It attained finality. So, even though whatever amount of oral evidence they might be adducing, lordship, that doesn't help in terms of section 91 of the Evidence Act, lordship. If I may take lordship to Evidence Act, please. Section 91, which is also having a corresponding provision in the new Act, my lord, BSA. But anyway, It
It's
also
okay,
will be safe
91, yeah.
to read from the Evidence Act itself. Chapter 6 of the exclusion of oral by documentary evidence. Lordship, if I may read, Section 91. Evidence of terms of contract, grants, and other disposition of property reduced to form of document. When the term of a contract or of a grant or of any other disposition of property have been reduced to the form of a documentary, in all cases in which any matter is required by law to be reduced to the form of a document, no evidence shall be given in proof of the terms of such contract, grant, or other disposition of property or of such matter except the document itself or secondary evidence of its contents, in cases in which secondary evidence is admissible under the provision hence herein before contained. If I may take again to the next section, Lordship, Section 92. 92 of the Evidence Act, Lordship. Exclusion of evidence of oral agreement. When the terms of any such contract, grant, or other disposition of property or any matter required by law to be reduced to the form of a document have been proved according to the last section, no evidence of any oral agreement or statement shall be admitted as between the parties to any such instruments or their representatives in interest for the purpose of contradicting, varying, adding to, or subtracting from its terms. Now, my Lord, regarding land pass laws, it is mandatorily required that anyone who is claiming to have an interest or a title to a land must have, my Lord, it is a settled law, must have a document in his favor in respect of that land. That is provided everywhere laws, including in our own land laws, my Lord. I think I may not need to enter into all details. As you Lordship knows very well, I cannot just go and claim that this is my land by verbal. No, I cannot do that, Lordship. Isn't it, Lordship? I have to have a documentary proof. So that is exactly what is Section 91 and 92 of the Evidence Act is talking about, my Lord. Whenever it is by law required that everything has to be reduced into writing and by document, and if that document is produced, Lordship, in the court, if that document itself is produced to prove, no amount of, Lordship, no amount of verbal oral evidence will defeat it, my Lord, unless they themselves can produce contradicting document, Lordship. That is my next point, my Lord.
Okay.
Next point, my Lord. Since, inasmuch as now I am having this duly, validly issued LSC in respect of the sued land, and they do not have it, how can, by any amount of verbal evidence, try to prove and defeat me and, Lordship, supersede this land, this LSC, my Lord? That cannot be allowed in the laws. Now my next point, Lordship. Right from the start, Lordship, even by reading the simple letter which the respondent, defendant has submitted to the learned trial court, Lordship, he stated that what he was allotted a land by the village council authority, Lordship. He said that village council leaders of Zonglong, he said that every time, even when we go through all the oral evidence which they deposed before the learned trial court, the main point, the main authority they rely on is the alleged allotment of land to them by the village council authority of Zonglong, regarding that, my Lord. If I may take a Lordship to this House Site Acts, these House Site Acts of 1953, Lordship, was the relevant House Site Acts at that time, my Lord, at that time of 1994, Lordship. This was replaced only in 2013 by the Mizoram Revenue Act, Lordship. Until that Revenue Act of 2013 came into existence, my lord. This was enforced. Lordship. This was enforced, Lord. So now, my lord, herein at if I may take your lordship to section 3.
What was the new act? Act
New
of
act is
2018?
The Mizoram Revenue Act 2013.
2013.
Mizoram Revenue Act 2013.
Yes, so here?
So the dispute, that alleged dispute arose in 1990, actually 2003, Lordship. They began, so at that time this was enforced. So if I may take Lordship, section 3 of that act, Lordship, allotment of sites. Is the Lordship with me? If I may read, Lordship, section 3 of that House Site Act, Lordship.
Yes.
Subject to the provision of subsection 2 of this section, a village council shall be competent to allot sites within its jurisdiction for residential and other non-agricultural purpose, with the exception of shops and stores, which include hotels and other business of the same nature. They have, village council authority have power, Lordship, to allot houses. But if we read below their mind, notwithstanding anything contained in this act, the executive committee shall have the power to intervene in all cases of dispute over any sites within the village, and the decision of executive committee shall be final. Executive committee means the then authority in the Mizo District Council, Lordship. At that time, Mizoram was not even an UT also. At that time, Mizoram was UT from 1972, Lordship. So at that time, 1953, it was only a Mizo District Council. It was autonomous body. Lordship.
You're reading section 3.
Section
3. No, it says administrator.
Yes, that is correct. Lordship.
Notwithstanding anything in this act, the administrator shall have the power.
Yes, administrator, when it was amended later, madam. Originally, it was set as executive committee, madam. Executive committee of that Mizo District.
So who is the administrator?
Administrator at that time would be what do they call that at that time?
District administration. This is the
I
DC.
I think at that time DC, yes. Which we now call it as DC. So I'd like to take your lordship to the next section, your lordship, subsection 2, your lordship. The executive committee or any other person or body authorized in that behalf by the executive committee or administrator, lordship, shall allot sites for residential and other non-agricultural purposes in, what I'd like to stress on, lordship, is this point. Aizawl, Lunglei, Demagiri, Sairang, Polasit, Champai, and Vanlaipa. Within this area, lordship, the village council authority did not have any power to allot sites for houses or agricultural purposes, except only with the approval of the executive authority at that time. That means administrator. So that was in 53X, and thereafter there is, even after that lordship, there seem to be cases arising wherein the village council authority, even within Aizawl, lordship, in contravention to this provision, used to issue house pass to some individuals within their area, lordship. And to make that, to clarify that one now, there was one executive order now. If this I may supply to lordship.
And this particular suitlet is an Aizawl.
Yes. This was issued way back in 1971. 71 years. So, if I may read, lordship, under section 3, subsection 1 of the Lusai Hills District House Site Act as amended, the executive committee, and we can read it as administrators of the Mizo District Council is pleased to declare that all lands within the jurisdiction of village councils of Luang Mual Tansil. So the Sud land is within Luang Mual laws. That is Luang Mual laws. And Sakor Chun shall henceforth be protected area laws. They are declared as a protected area within the meaning of
What does protected area mean?
protected area means a certain area or village within which
No
within
allotment.
which no allotment of land has to be made by the village council authority except by the approval of the government. That means executive authority of the Mizo District Council. So what I try to point out was herein on this point is that since that the Luang Mual area, that means the Sud land way back in that 1971 was declared as a protected area wherein village council authority did not have any power to allot any land pass including house sites. So now my learned friend client is claiming that they have been allotted house site in that area by village council authority. That is actually not having any authority to allot any land pass. That also was done very recently in 1994 also, that they claimed that they had been allotted the house site land in 1994. That, my lord, cannot be allowed in law. Because any allotment at that time made by village council authority would be void. It has no force of law. It will only, at best, lordship, be a simple arrangement made by the village council authority. They did not have any power to allot land at that time within the protected area. And that too, within Aizol, man. That Aizol area, man. That the House Site Act itself specifically said that within Aizol, this allotment of land, including house site, cannot be done by village council authority laws. So actually, they even accepting, my lord, even accepting their written statement, my lord, which they said that they have filed, my lord. Even accepting, my lord. Even if I'm to accept, but their pleading, whatever their pleading was that based on they rely on authority of the village council authority, saying that the village council authority of Luang Mual allotted them the present Sud land wherein they now reside and build their houses. That is, my lord, unauthorized occupation of my land. Village council authority of Luang Mual did not have any power to allot land to the respondent defendant.
But just come to your cross-examination. In your cross-examination, you stated that during the year 94-95, the village councils of Zonam allocated house site to residents of Zonam at
Yes, they
Barapu Mall
used it.
area.
That is exactly why, my lord.
So you were also allocated that house site during this time.
It seems they make some arrangement, not allotment. That is not having an illegal value, my lord. My authority flows from the Revenue Act, my lord, by issuing this LSC, my lord. That is a simple arrangement, my lord. That mere arrangement or allotment, whatever they call it, they may name it whatever proceeding they have it lawsuit. They did not have any power laws. They did not have any power to allot any house site lots. They may allot it to some other person also, my lord. But all those, my lord, do not have any, they do not have any subsequent legal entity, Lords. All those arrangements made by the Village Council Authority of Luang Molil. Even to me, my Lord. Even to me, they wrote it, but that doesn't have any meaning, my Lord. Unless that is acted upon by the competent authority in the review department, Lords. They even may allot to me, may allot to respondent, may allot to some other good number of persons, my Lord. But that doesn't have any legal effect until that is acted upon, my Lord, by the competent authority, Lordship, in the review department of the state government. And in my case, my Lord, in my case, I have applied not to the Village Council Authority, Lordship. I applied to the competent authority in the revenue department, Lordship. Accordingly, I was issued this present land settlement certificate in respect of my land, Lordship. That is, they admitted, it is admittedly covering the whole area now occupied by the respondent defendant, Lordship. Whatever arrangement, whatever allotment, Lordship, done by the local council authority, the village council authorities of Luang Molil, my Lord, let that be whatever, my Lord. The fact remains, Lordship, the fact remains that I have been duly issued a land certificate, Lordship, land settlement certificate, wherein I have been declared as legal owner of the land. And that, Lordship, still stand today. They have not challenged it, Lordship. They have not challenged that duly issued land settlement certificate issued by the competent authority in the department in my favor, in respect of the suit land. It's undisputed, Lordship.
When the land was demarcated in 2006, after the revenue department came and demarcated the land to issue the LSC, why the defendant was not given LSC then? Why his land was not demarcated?
That's up to the revenue department to answer, Lordship. And, my Lord, very interesting, as your Lordship points out now. If they are aggrieved with non-issuance of any LSC in their favor, they have to challenge the non-issuance of that LSC by the respondent defendant. They have to challenge it before the court, Lordship. That they have not done till date, my Lord. They simply settled inside my land, my Lord. They have to challenge. They have to go to the court, saying that they have to also duly issue settlement certificate in respect of whatever plot of land that they are claiming that their land is there. That they have not done till date, Lordship. They simply settle within my land. And even then, my Lord, they also have not challenged my LSC, my Lord, till date. My certificate, they have not challenged it till date. They should have challenged it. If their contention is that my LSC is covering their land, they should file a case, both against me and the state government in the review department, madam, saying that that is wrongly issued. That they have not done in Lordship. So, from 2006 to 2025, how many years have now passed that they have not done? So, they are now stopped from making any claim as of now. If I may take Lordship to one Land and Revenue Act of 1956, my Lord. Land and Revenue Act. This is the act under which at that relevant time, my lord, LSC and other passes were issued by the review authorities also. Herein, I'd like to take lordship to section 4, lordship. Section 4 of the then Land and Revenue Act, lordship.
Section 4.
Section 4.
No person shall acquire.
Yes, Your Lordship, exactly. No person shall acquire by length of possession or otherwise any right over land. My lord, they cannot by length of any length of possession acquire any title over the land. And now, if I may take Your Lordship again to section 12, Your Lordship. Section 12.
Oh, this is also Lushai Hills Act.
My lord.
The same one.
No, actually. The earlier one was
This one
Act.
is 53.
This one is Land and Revenue Act, 1956, Your Lordship. This is 56 Act. Yes,
Oh,
it
okay,
was
okay.
relevant at that time. It was, this is also replaced only by the 2013 Act, Your Lordship. Until 2013, this act was used in the state, my lord. This was the law enforced. Section 12 says the position of LSC holder, Your Lordship.
The local ownership over land.
Yes, legal ownership. Legal ownership over land. If I may read, Lordship. Possession of such certificate showing details of boundary, area and assessed revenue to be paid annually shall be deemed to be the conclusive proof that the land has been settled with the holder of the certificate, and that all rights and interests arising out of such settlement have vested in such holder of the certificate. Now, my lord, I was duly issued this LSC by the competent authority in the revenue department in my favor, lordship, over the disputed area, lordship. So, by virtue, in terms of this section 12, my lord, I have the legal ownership, undisputed legal ownership, unless that LSC, lordship, that certificate has been quashed, cancelled by the issuing authority, lordship. That, my lord, has now not been done, my lord. They have not challenged the lordship before the revenue authority also. And if they feel that their efforts are futile, they should have filed appropriate suit before the court, my lord, challenging the non-issuance of LSC in their favor, lordship. But they have not done. And as far as that is not done, my lord, in terms of section 12 of this act, lordship, I have legal authority and ownership over the land, wherein my LSC covers, lordship.
Yes. Next.
Regarding that, my lord, I'd like to place one reliance. I place reliance on one citation from the from the Court of Lordship, Kerala High Court, lordship. There is one. Even though I looked for it and did not find any relevant one, but I found this in the judgment of the Kerala High Court, lordship. 2025 SCC online. paragraph number 23, Lordship. 23, Lordship. 23. This is regarding a pleading without verification and affidavit, Lordship. A pleading which is not supported by verification and pleading, my Lord. If I may read, Lordship. In the present case, the defendant number 2 executed the exhibit A to sell it in favor of so and so, so and so, so and so. And my Lord, I'll skip here and I'll go to the last last part of that paragraph, Lordship, if I may be allowed. On that same page, Lordship, in the middle of that paragraph, Lordship, a pleading, is your Lordship with me? A pleading without verification. Yes. And an affidavit as required under Order 6, Rule 15, CPC could not be treated as a valid pleading. That is a court-led bench of Kerala High Court, my Lord, has come to that decision. And that very much, my Lord, is in conformity with the provisions of Order 6, Rule 15 of the CPC. Very much. That may actually need not be supported by any reliance from the judgment of the court, my Lord. Actually, the statutory provision itself is very clear, Lord. The CPC itself is very clear, so this might also not be required, my Lord. And now, if I might take a Lordship to one point which my learned friend used to rely, my Lord, saying that now, even though, my Lord, even though they said that they have not enclosed any legal documents regarding land pass, my Lord, still they used to claim that their matter has been moved to be internally in the review department, my Lord, and that they try to slip in the present case itself, even after appeal was filed, my Lord. And that is therein, my Lord, the IA file, this is connected IA file in this case, my Lord, wherein they are praying that all these leading documents, my Lord, which they said that they obtained it, my Lord, they said that they obtained it through RTI after decree has been pronounced in the present case, my Lord. That they said that that's been, they try to put on record, my Lord, all these documents for the present case. That even though cannot be allowed, my Lord, even, my Lord, even accepting all these processes, my Lord, the documents, even accepting to put all these documents which they try to put on record, my Lord, they, my Lord, actually are correspondences and some orders of detailment of revenue surveyors. All these, my Lord, are internal file movement, my Lord, which they try to put on record, my Lord, which cannot be allowed in terms of the relevant provisions of CPC Lordship. Order 41.
What is this IA? Who is
IA is filed under Order 41, Rule 27 of CPC Lordship for bringing on record the documents which they said that they later obtained it after trial has been finished, my Lord. They try to bring it on record again, belatedly, Lordship.
Lordship, these are IAs we had filed. So what happened was, my Lord, it's clear from the examination, in the cross-examination of the defendant itself, my Lord, he has stated clearly that he had applied for an RTI application regarding the developments that had taken place between these two people, my Lord, between the two parties. Now, from the list of dates itself, it's very clear that on the date he was cross-examined, my Lord, these documents were not provided to him. He was cross-examined on, let's say, 11th of June 2011, my lord. These documents were provided to him on 17th of June 2007. I mean, much later. But it was already during the pendency of the case that these applications were made. So now that we have the decree in our favor, my lord, and they have filed an appeal, we believe, my lord, that it will be good for the court to see these documents. And that is the reason why we have filed.
There is a very limited scope under Order 41, Rule 27, my lord. Order 47, Rule 21 says that unless any document is within the knowledge of the party during the trial, the time of trial in the court, my lord, they, your lordship, at the appellate stage, my lordship, cannot be allowed to bring it on record, any documents which they try to do it, my lord. Now, they try to put all these documents on record, belatedly, my lord. And regarding this application, lordship, I'd like to point out that, lordship.
1 minute.
Yes. They said that they obtained it in June 2016, lordship. They said that they obtained this RTI information, lordship, in June 2016, lordship. That was, lordship.
Information was obtained when?
June 2016, as per their statement, lordship.
June 2016.
Okay, lordship. And at that time, my lord, trial was going on. Trial was going on. And the impugned judgment hearing was pronounced way back only in, if I'm mistaken, 2019, lordship. Am I correct? Pronounced in 14th of June 2019. From the date they obtained this RTI information till the date this was finally ultimately disposed, there were 3 long years, lordship. 3 long years. They have a chance of 3 long years to file before the trial court, lordship. That they have not done. And now belatedly they try to put it on record, my lord. That, my lord, cannot be allowed in law. At the time, as per the statement that they obtained way back in 2016, June, lordship, if they actually obtained it by that time, my lord, if they actually were interested to file it and put it on record, lordship, in the trial case of this present case, lordship, they could very well have applied for before the trial court and put it on record at that time, lordship, way back in 2016, lordship. That they have not done, lordship. My lord, please, it's very interesting, lordship. And now, my lord, they have not filed it in 2016, 17, 18, 19, lordship. 19 judgment was pronounced. They win the case, lordship. And then we filed the present RFA in 2019 itself, lordship. We filed the present appeal in 2019 itself. My lord, they applied for inclusion and put it on record only in July 2024, lordship. 19, 20, 21, 22, 23, 24. 5 years, my lord. What are they doing during those 5 years again, lordship? Even after the pronouncement of the judgment, lordship. So actually, altogether 8 years, lordship, have passed from the time they obtained this RTI information till the time they tried to file it and put it on record, all these documents which they obtained, they said in June 2016, my lord. That, my lord, is hard to believe, lordship. And actually, these actually cannot be relied on, my lord. These cannot be put on record also. And, my lord, that is number one. That cannot be allowed. In terms of Order 41, Rule 27 of the CPC. It's a very limited scope, is there, lordship. And, but not admitting, supposing, but not admitting, lordship. It's put on record. Okay, lordship. Right? Now, what does that, all those documents contain, lordship? Let's take a quick glance, lordship.
So what are the documents he is producing in the IA?
Yes, lordship. Page number, internal page number 10. Number 10 of the petition, lordship, is supply of information Yes, actually, it was supplied to him on 17 June 2016, Lordship. And next page 10A is also English translation, and page 11, Lordship, is the order allegedly issued by the Revenue ASO Assistant Director, Lordship. And all these, Lordship, all these and 13, my Lord, is checking pro forma 14, 15, Lordship. This allegedly seems to be internal file movement, my Lord. Internal file movement. That's it. They are all here. Some of them are maps, some of them are detailment of surveyors to go to the spot and verify and take measurement and do spot verification, Lordship. And some are tax payment receipt, some are acknowledgement letter. All these, Lordship. If we go through all these, Lordship. And the last one is my LSC, Lordship. From all these documents, my Lord, what is clear? What is clear is that, my Lord, there is no decision, Lordship, there is no decision made by the competent authority in the Revenue Department also. Even accepting these documents, my Lord, doesn't help their case. These are only file movement and orders and detailments that never materialize into any fruitful order, Lordship. These never materialize into issuing of any order in favor of the defendant respondent, Lordship, in respect of the suit land. Even at best, Lordship, even assuming but not admitting that this is admitted, put on the court, doesn't help their case. Because, Lordship, they have not challenged my LSC, Lordship. They have not challenged. That is a duly and competent, issued by competent authority of the Revenue Department. All these document doesn't change the legal entity, my Lord. All this never materialize into a fruitful order, my Lord. Regarding this, if I may please relies on one just citation, Lordship. 2011, Volume 8 SCC, paragraph 24, Lordship. 24, Lordship. Paragraph number 24.
Yes.
If I may read, Lordship. A noting recorded in the file is merely a noting simpliciter and nothing more. It merely represents expression of opinions by the particular individual. By no stretch of imagination can such noting be treated as a decision of the government. Even accepting all these documents of movement of file, my Lord, that never materialize into a fruitful order, Lordship, in their favor. No fruitful order saying that LSC has to be issued to the respondent, defendant. No, nothing came, my Lord, out of all these documents. So, since all these file noting, file movement, correspondence, my Lord, doesn't help their case in terms of the judgment of the Supreme Court, Lordship, unless a competent authority issued a consequential order, my Lord, following that decision made in the file noting, my Lord. Even actually, my Lord, here, there is actually also no file noting is there, my Lord, saying that decision is made, so nothing, my Lord. Only correspondences and receipts of revenue payment, my Lord. Nothing, my Lord. Only some are detainment, some are forms, which is used by the revenue authority, my Lord. that, my lord, never has been acted upon. Never acted upon. All this document has never been acted upon and never materialized into any fruitful order in favor of the respondent, my lord. In the hands of the competent authority of the Revenue Department. Whereas, Lord, in my case, my lord, I have a duly issued LSC covering the whole area, my lord. And that LSC has till date never been challenged. And that attained finality that has never been challenged till date, Lordship. So, when, Lordship, as a
Yes.
as a conclusion, Lordship, if you take it like this, when a legally valid document is pitted against oral evidence, Lordship. Now I have a legally valid document issued in respect of the sued land, whereas they do not have any legally valid document. That is an admitted fact, Lordship. And what they try to do is now try to put on record all these miscellaneous documents, my lord, that actually do not have any legal value of conferring any title to the respondent, my lord. Now, when legally valid document is pitted against oral evidence, now as I just read it to your lordship, in terms of section 90 and 91 of the Evidence Act, your lordship, it doesn't stand a chance. So there is no chance, not a question of oral evidence defeating the legally issued document, unless that is duly challenged in a court of law and quashed it. So that will be the sum and substance of my submission before the lordship today. And if there need arises any rebuttal, lordship, if I may kindly be given a chance after my learned friend finish their submission.
Okay. No, admittedly, there was something. Both of you were allotted land at the same time, but it so happened that when his land was demarcated, you were either not aware or you did also immediately you did not lodge any complaint, nor did you challenge his LSC. So by this, in this particular suit, when when he had filed a suit, so and with a valid LSC, then the trial court have decreed in such a manner?
My lordship has put it very succinctly, my lord. And the issue, my lord, but let me try to place your lordship the facts which your lordship has not been provided with, my lord. Now, my learned friend is in a rush, my lord, but I think we can finish it off. She can wait, my lord.
No, we can keep it parted and we can continue on Monday also.
We can keep it on Monday also,
no problem.
But let me give your lordship just a small facts of the case, my lord, so that your lordship can understand it during the weekend also, my lord. Now, what has happened, my lord? After the insurgency had happened, there were quite a few very, very poor people, my lord, who were living in a place called Remnaroon in Luangwal, my lord. There is an area beside where your lordship's quarter is, beside the guest house, your lordship will see above that area. There is one area called Remnaroon, my lord, where all these people who have suffered because of insurgency or people who took part in the insurgency movement, my lord, where they were living and they did not have any land, they were poor people without any homes. Now, it so happened, my lord, that my client and his client, they were one of those poor people. Now, 1986, they were living in Remnaroon, my lord. Now, the government, and my learned friend has mentioned, has made it seem like there is no approval from the government, my lord. But the RTI reply we got, my lord, is very, very important in this respect. Now, what happened was, with the acknowledgement of the government, my lord, in 1994 to 95, The village council of Luang Mual, my lord. That is because everything was a village at that time. Aizawl itself was almost like a village, my lord. And Luang Mual, even though your lordship comes today, it feels like it's one place. But in 1994, my lord, even when because I live close to that area, when we started living there, my lord, the entire place was jungle. That hospital there does not exist, my lord. The new secretariat itself was almost like a jungle, my lord, this place. And that area, my lord, was quite far from Aizawl. There was one bus service even in 2001.
That was not part of Aizawl.
That was a different village only. Luang Mual village chief, my lord, was a well-known village chief. So 1994-95, the village council of Luang Mual at that time, my lord, they had allotted a portion of the land in Zonuam for this kind of poor people. This was all with the authorization of the government. In fact, the government has made a map, my lord, and I'll provide this to your lordship. And in this land, in this area, my lord, they were allotted a land just like us. In the map, their names are given, our names are also given. 1999, because they are extremely poor people, my lord, with the help of the YMA, means Young Mizo Association, including us, my lord, we were also present. We helped them construct their house, my lord, in the area allotted to them. They are neighbors, my lord. 1999, their house was constructed. 2002, our house got constructed. We lived peacefully, my lord. There was absolutely no problem between us. There was no conflict at all. 2003, my lord, what happened was the revenue department took a step to regularize those allotments which were made, my lord. All the allotments. So your lordship will understand, my lord, that the village council had not allotted it randomly, because otherwise the government would have not come and formally regularized it, my lord. So the government comes and regularizes it in 2003. Now, as per the written statement submitted by my client, my lord, he was not aware in 2000. He was not in his locality. He had gone somewhere, he said, that day. He did not know. So in his absence, there was a house passes where, because the maps are already there, no proper demarcation needed to be made. It was already made. So in his absence, his client pointed his own land and the land of my client to be his land. So in his absence in 2003, house passes were made. But house passes, my lord, during those days were they were not a big deal, my lord. Those house passes, my lord, within few years, my lord, that is only in 2-3 years, they got made into LSC, land settlement certificates. Now, when land settlement certificates were issued, my lord, that was the only time when my client had come to know that this kind of things was happening behind his back. That when he had gone to get his land certificate, he did not get. He realized that his land also was included in his land. Then, my lord, the dispute
that's
started.
why didn't you immediately challenge that?
He challenged. I will provide to your lordship. He challenged it. Now he went to the Land Revenue and Settlement Department. Immediately, my lord, the Land Settlement Revenue Department, they started taking steps, and we have provided all these documents in the IA, my lord. And now what the Land Revenue Settlement Department, during those days, my lord, this is before 2013. 2013 Act, my lord, for the first time in Mizoram, introduced the Registration Act. Before 2013, Mizoram, my lord, there was no concept of registering your land documents or registration of sale deeds. So what the Revenue Department did was they came up with this solution, my lord, that he has to give back that portion of the land to me. And in fact, he has signed it. If your lordship will take your lordship to those documents which we had filed. There it says, in Muninpegna, which is gifting of land documents. So he has gifted that portion back to me, because that could be the only solution the government could have come up with. Now he has also filed something called Muninpegna Lekha, which, transfer of land application document. He had made an application for transfer of land in my favor before the Land Revenue and Authority, because the authorities had asked him to do it. And he has also filed one thing called the No Objection Certificate, my lord, where he signed, along with some other people, that that area portion should be given to me. And the Land Revenue Settlement Department, they came, they made all the demarcations, they put all their, those pillars and all that, my lord. And then he returned his original LSC also to the Land Revenue and Settlement Department. And now what the Land Revenue Settlement Department did was they made all the demarcations, they made all the new maps, they put all the boundary pillars, everything was done, my lord. And then all he had to do was he had to pay the bifurcation fee. The revenue said that the bifurcation fee has to be paid by the appellant, because he was the one who had done something wrong, my lord. He was supposed to pay the bifurcation fee, and he did not pay the bifurcation fee, and we waited for him to pay the bifurcation fee. Instead, he came to this court, my lord. Sorry, he went to the civil court filing the evictions.
No, but all these things, were they brought to the notice of the trial court?
They were not brought to the notice of the trial court.
See,
He
that's
did
what
not
I'm
challenge
saying.
them. Because
No, but because of that, now our hands are tied in this appeal.
no, that is
You
the
understand?
reason why. Correct.
Ah.
That is the reason why, my lord. That is the reason why we
So
filed
can
order
the court
41.
in this RFA go into all that?
Yes, because CPC provides it. CPC,
I
my lord, your
don't
lordship
think
will
so.
come to order 41, rule 27.
In appeal.
In appeal, my lord. Your lordship, order
When
41,
all
my-
these documents were never brought to the notice of the trial court.
But it can be done, my lord, because order 41, rule 27, my lord. Because, my lord, this is CPC order 41, rule 27, my lord, and I have the Supreme Court judgments also, my lord, in this favor. My lord, it says like this: the parties seeking to produce a, I'll read, my lord. The parties to an appeal shall not be entitled to produce additional evidence, whether oral or document, in the appellate court, but if A, the court from whose decree the appeal is preferred has refused to admit the evidence which ought to have been admitted. My lord, we don't come under this. Or B, the party seeking to produce additional evidence establishes that notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the decree appealed against was passed. Or B, third, the appellate court requires any document to be produced or any witness to be examined to enable it to produce judgment or for any other substantial cause. Now, my humble understanding, my humble submission, my lord, is that unless these documents are appreciated by the court, and these documents, my lord, are in line with the judgment of the lower court as well, because the admitted records make it very clear, my lord. If your lordship will see the paper book, your lordship will see this was an exhibit of the appellant.
But you came to know about all this in 2016.
Which one, my lord? This.
The subsequent developments and then the documents.
No, my
You came
lord,
to know.
we did not come to know only in 2016. If your lordship will see our examination in cross-examination at page 49, my lord. We have stated like this. Page 49, re-examination, my lord, says like this. Because the defendant, the respondent number one, had mentioned all of this in his written statement in detail, my lord. Even though the documents were not there, he has stated in detail. It says like this: by saying para number 7 of my cross-examination 1, what I want to mention is that though I have no document to show that the plaintiff's LSC has to be partitioned into 2 at present, however, I have applied for the said document by filing an application by way of RTI to the concerned authority, and the said application is still pending till date. Now, if your lordship will see the date, the signature was given was 9/6/2016. 9/6/2016. These documents were provided, my lord. As per our application on 17/6/2016 at page number 10, my lord.
Yes, 17/6/2016.
2016. So this was after his cross-examination was done.
No, even then, at that point, you could have submitted an application before the trial court,
but this
praying for additional
Correct,
evidence.
We could have done it, my
Yes.
lord. But he did not do
Because
that.
judgment was only in 14/6/2019.
2019. But
Yes.
one thing, my lord, is let me take your lordship to the paper book itself, my lord. Because in the paper book itself, it's already mentioned.
Okay, we will hear you. We will hear you on Monday.
Yes, my lord, certainly.
I'll keep that in mind. Order 41, Rule 27. Yes.
Your Lordship?
Yes.
If I would...
You also submit on Monday? Yes.
Your Lordship, it's a very small comments from the Land Revenue Department. I will just submit it to you.
But they did not file their WS, my lord.
We have not filed, but however, Your Lordship...
Actually, they are not
So if they
contesting.
have not filed their WS, they cannot come at this stage.
Government did not file WS before the trial court.
The same, Your Lordship, the same document as I have submitted earlier to Your Lordship. It may also be safely filed now, my Lord, to Your Lordship.
They can only, my lord, they can only argue on...
It is only on the point of clarification of law, Lordship. On the point of law. Point of law can be raised at any time.
Yes, that can be raised.
Yes, actually...
Legal point can be raised.
Point of law can be raised
but
at any
not
time.
on facts.
Your Lordship, if I may be allowed to produce this before you.
It's a point of
What
law.
is that?
Point of law, Your Lordship.
It is a point. So, Your Lordship, if I may be allowed to submit the copy and can be considered on Monday.
No, no, it's a letter.
Your Lordship, it is just a small comment on the LSC. Your Lordship.
It's not part of the record, basically.
But it's a point of law, Your Lordship. Point of law can be raised at any stage, Your Lordship.
Okay, okay, let's. Maybe for court's knowledge, we can.
It's actually the document the government rely on is the same, exactly the same document which I supplied to Your Lordship, and which is also part of the record here in Your Lordship. It is same as my submission, Your Lordship.
Okay. Heard learned counsel for the appellant, Mr. Sir and such. So, matter is part heard, list as part heard as a fixed item on Monday, 27th. Yes. These judgments, you just get photocopies of these judgments, okay?
Item number 14.
There's no time actually. Can we hear it next week?
The councils are not there only.
Oh, councils are not there. Okay. Who is for the appellant? Appellant is not there.
In this case, we are not parties.
Oh, okay. And the parties are not present when the matter is called. So, this is the matter for hearing after 2 weeks. For hearing after 2 weeks.
Item 17.
No, no one is there, my lord.
No
We are
one
the
is
only
there.
councils left, my lord.
Oh,
Everyone
okay.
thought we were going to finish off.
So, same order. Then none appears for the parties when the matter is called. List after 2 weeks for hearing. Yes. Any more? That's all. This is like Kohima. 2 o'clock, nobody's there.